Hi, my name is Arati and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas Co is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. For today's showcase, I'm delighted to introduce you to Pranay. A graduate of Gujarat National Law University, Pranay takes a keen interest in understanding the intersection of technology and legal frameworks. While in college, he actively participated in research projects, courses, and workshops and completed a graduate certification program on technology policy. His commitment to ethical and responsible use of technology led him to focus on algorithmic accountability, an area where the consequences of technological decisions can significantly impact individuals and society at large. Transitioning into a professional career, Pranay works with a technology team at a leading law firm in India, where he continues to advise clients on cutting edge matters, leveraging his experience in policy law and technology to provide comprehensive and innovative solutions. So, thank you so much for joining us, Pranay, and look forward to hearing from you today.
Thanks, Arti. The pleasure is all mine. If I can share my screen now. Hi, everyone. My name is Pranay, and as part of the Meta India Tech Scholar 2022-23 program, I prepared my research paper on recommendations for recommending guide global insights to guide the Indian approach. Now, the reason why I chose this topic was primarily because algorithms govern practically all the content that we see on social media platforms today. And we have various studies which show that it negatively contributes to amplification of harmful content. Now, even though platforms have taken significant actions, both under requirements under law as well as voluntary actions uh, to curb the amplification of problematic content, there is a growing dialogue in the community that platforms are not doing enough, and regulators are taking note of it. Now, the purpose of the study is to see what regulators across the globe have been doing, what actions have been coming into the fore to address the challenges of recommender systems. And as India gears towards the Digital India Act, the study aims to make some recommendations as to what approaches can be adopted by India and may be relevant for India to chart its path forward. Now, the methodology adopted for this research is primarily a comparative analysis where I've studied what other jurisdictions are doing in terms of regulating recommender systems. And this study has been undertaken with the assumption that to regulate any form of AI, we should not create laws or reinvent the wheel, but merely create regulations that supplement the enforcement of existing laws. Now, in India, we have general principles of fairness, accountability, and transparency under the Constitution of India. And we can also find these principles under various legislation such as Consumer Protection Act and the IT Act. Now, while these principles have not been interpreted in the context of algorithms, there is an argument that these legislations may may guide platforms' decision-making process, including the applicability to recommender systems. Therefore, any new regulation or any new step that India takes towards regulating recommender systems, these these steps should only supplement the enforcement of existing principles that we already have under the governing frameworks. With this, we move forward to the alternatives, which also serve as the broad planks based on which the research has been premised. These are generally the approaches that regulators have been undertaking across various jurisdictions. And these approaches include modifying platform immunities, adopting content neutral legislations, and lastly, the principles for transparency and accountability. Moving on to alternatives one and two, we'll first talk about modifying platform immunities. Now, this argument is based on the premise that problematic content spreads because of platform immunities. In India, we have this under the Information Technology Act, and in the US, this can be found under Section 230 of the Communications and Decency Act. Now, based on this premise, recent cases have recommended that, sorry, just the recommendation. Based on the premise, recent cases like Gonzalez versus Google and Tamna versus Twitter have witnessed petitioners making the argument that platforms contribute to the spread of terrorism content. Now, this is based on the premise that through the algorithmic systems on the platforms and the recommender systems, this contributes significantly to the spread of terrorism content. Now, the primary argument in this context is that as a result, platform immunities should be taken away and such that platforms do more to remove content that is problematic on their platforms. Now, this leads to the impact that this gives platforms a very huge discretionary power to remove content that is problematic. And as a result, this may lead to over enforcement against harmful yet lawful speech. And this might also result in platform eliminating recommendations altogether, because if platforms are no longer protected by the safe harbor immunity, platforms would tend to err on the side of caution and eliminate recommendations altogether. And as a result of such enforcement and eliminating recommendations, this would impact protected user speech. The second approach that we have is based on content neutral legislations. Now, these recommendations are based on the premise that platforms suppress legitimate speech and distort political discourse. To combat this challenge, legislations such as the Texas HB 20 and the Florida Bill 7072 have recently recommended that platforms should adopt anti censorship measures, and they should practically carry all forms of speech irrespective of the viewpoint of the user. So, this would practically turn the platforms into common carriers, which is a term used to define platforms where speech can be carried freely without any restrictions. We have a similar provision under the intermediary rules in India, where any appeal made to the grievance appellate committee, uh, in case the GAC determines that the content has to be upheld by the platform is under an obligation to uphold that content. So this the impact of these recommendations would be that platforms will have basically no editorial discretion in deciding what content should be there on the platforms. And as a result, the government would be in a position to dictate what speech should be there on platforms. And this gives like a uh, very broad power to the government in terms of content that is hosted on the platforms. Recognizing these challenges, it's not the various courts in US have also taken note of these legislations, but currently there seems to be a split between the Fifth Circuit and the 11th Circuit when it comes to the Texas and Florida legislations. And as a result, the Supreme Court of the United States is yet to hear on these legislations. So until then, there is no clarity as to how the provisions of these legislations would apply to social media platforms. So as a result, given until we have more clarity, the impact of these recommendations is such that implementing these principles would be technically infeasible, and platforms requiring to carry problematic content would also be a significant challenge for platforms. Uh, and as I said previously, this would also impact the editorial decision making of platforms, something which is recognized as a protected form of speech, at least in other jurisdictions. These tweets, both on left and right, will will may give you an example of how these principles may be interpreted and how these principles may cause various kind of problems for social media platforms. Both these tweets are equally protected forms of speech, although they may be problematic in their own context. But if either of these premises that we noted previously, which is that problematic content spreads because of platform immunities and platforms suppress legitimate speech and distort political discourse, following these premises, the result on both these tweets would be that removing either of these tweets would would not solve the problem of platform immunity because both are protected form of speech and safe harbor immunity has nothing to do with these tweets. And secondly, if any legislation mandates platform to carry diverse viewpoints, both these tweets would need to be carried, and this would significantly impact the platform's editorial decision making powers. And this would also result in a kind of a paradox because on one side platforms need to take down certain kind of speech to ensure that the users do not come across problematic content, and at the same time platforms would be required to carry diverse viewpoints. So this would be a very conflicted situation for platforms to operationalize these kind of requirements. Summarizing the principles so far, wherever platforms decide speech, there needs to be oversight, and this could be through various kind of regulations, which broadly set out the playing field for how these platforms can decide speech. Users' decisions on platforms to decide speech needs to be enabled. And lastly, wherever government decides speech, that must be avoided, as seen in the case of the Texas and Florida legislations. Now, there is an argument that we need to decouple safe harbor immunity from platform liability. And there is an argument that we need to decouple platform immunity with the conditions that platforms need to undertake to ensure that the content on its platform are aligned with various rules and regulations. And this is where we segue into our third alternative, which is requiring platforms to adopt transparency and accountability measures. Now, these measures need to be undertaken across the algorithmic lifecycle, which starts at algorithmic development. This is the development stage. And at this stage, regulators and service providers, they need to collaborate with each other to, to facilitate the development process. Secondly, where we are talking about algorithmic intent, at this stage, there should be a systematic duty to take care on platforms for platforms, and the values that need to be maximized by the recommender systems can also be defined at this stage. And lastly, the algorithmic effect stage. At this stage, user and researcher transparency needs to be encouraged, and there also needs to be provisions for auditability and user empowerment. Each of these stages are not monoliths, and the cycle would follow consistently because the development life cycle of algorithms is a consistent process. As we'll see in the next slide, uh, we can see how these algorithmic life cycles, uh, uh, how these regulations can be adopted across the algorithmic life cycle based on examples from what we have seen in various jurisdictions. Now, on the left side of the table, we have the positives, and on the right side, we have the negatives. So, at the algorithmic development stage, we have seen measures to take self-risk assessment, the uh, to coordinate with digital services coordinator and taking safeguards for confidential information. Now, these are the recommendations which we can find under the DSA and the Online Safety Act. However, on right at this stage, the measures that need to be avoided are interventions which mandate platforms to disclose their algorithmic model, or state interventions in conducting security assessments. And these are the recommendations that we can see coming from the Chinese regulation. At the second stage, which is regulating the algorithmic intent, we need to look into proportionate measures which place equal duties about on for safety and for controlling illegal content. And we need to adopt tactics. Again, this is a recommendation which has been made in the Chinese regulation, which prescribes certain measures to for content moderation, such as deweighting, scattering, interventions for transparency of search, etc. At the second stage, the measures that need to be avoided are the use of proactive technologies and defining values narrowly. At the third stage, which is regulating the algorithmic effect, something which is very novel and which is quite encouraged is researcher access to systems data of the platforms of, under confidentiality obligations as safeguards, because this would enable the scientific community to study the impact of these systems at a much more deeper and granular level. There also needs to be arrangements about for research and user experience. This is something which would also improve the center's capability significantly. At this stage, there also needs to be clear indications about algorithmic recommendation services, basic principles, purpose, motives, and main operational principles. Now, these are the recommendations that have been prescribed under the UK Online Safety Bill. Now, at this stage, the obligations that need to be avoided are are broadly defined obligations on platforms to empower users and publicly disclosing information that is shared with the regulators by social media platforms. Looking at the implementation roadmap, the first step is co-regulation, and this is the stage which suggests that we need to adopt a systems thinking approach, and there needs to be collaboration between the industry and the government. The second step is to address capacity gaps. We can take we can take inspiration from the EU, where the government has set up the ECAT, which is a center for studying the impact of algorithms specifically and to inform the decisions of the regulators. And lastly, going back to our initial point that we need to harmonize existing frameworks and we need to leverage the principles as much as we can that we currently have. With this, if you have any questions, I'm happy to take them up.
All right, thank you so much for that, Pranay. That was an interesting exposition on basically how you hold algorithms and platforms accountable within this sort of whole liability-free framework that they're existing in globally. And I think that sort of brings me to my first question, which is that that framework in India might be changing. So if we look at these discussions on the Digital India Act or bill, which is supposed to, which we still don't know much about, but which is supposed to replace the Information and Technology Act, we've seen government spokespersons constantly talking about how they want the bill to really reinvent the wheel when it comes to safe harbor and provide different kinds of safe harbor frameworks for different kinds of platforms and sort of introduce a whole new range of speech-related harms and just general online harms as well. So given that one of your recommendations was actually that we shouldn't be reinventing the wheel, that we should be harmonizing existing frameworks, my question essentially is, how do you see this new approach essentially affecting the balance between user, company, and government interests when it comes to algorithmic regulation in general?
Yeah, that's a very interesting thought, Aarti. And I think thinking about it, it would depend on what direction the government is taking. Like I said, if the approach is one where, let's say, existing safe harbor is retained, but it's decoupled from platform liability, or maybe let's say if additional obligations are introduced, and instead of removing immunities for platform, if these obligations require platforms to go the extra mile, I think that would certainly tilt the balance in favor of the users as well as the platforms if we adopt more self-regulatory approaches and if we adopt more approaches to empower users and give them more control over how they wish to see content online.
Right.
But if the approach is one where we are trying to sort of build on the existing safe harbor framework and introducing, let's say, more obligations under the existing frameworks. I think that approach is unlikely to work because, as a baseline, we certainly need platform immunities, and any existing obligations should not be linked to the immunity per se, but could be introduced as a separate measure, is what I feel.
Okay, great. Thank you for that. And just the second one. So you mentioned different approaches from across the world, the UK, the EU, China, of course. And of course, there are many more countries, regulating the internet and the platforms on it. So which, based on your survey, which country do you think is best balancing all the stakeholder interests that you were speaking about? And what can India learn from them, given that we're in this transitory period? So just your thoughts on that.
Thinking about it, Aarti, I personally feel that the legislation which uniquely stood out was the Digital Services Act. So one of the main reasons why I say so is because it seeks to empower researchers and bring the scientific community into the picture. So where they can formally look into these systems and study what impact or implication these recommender systems have on users. And I think if we were to adopt such an approach, that would really inculcate the culture of research. And I think that is one of the reasons why the DSA stands out. The other reason is overall the approach in the EU to coordinate with this European Center for Transparency and Accountability. So where the ECAT informs the government's decision on how to regulate these novel systems, and I think that to a large extent addresses the issue of capacity gaps.
Right.
So yeah, I think for these reasons particularly, I mean, I think the DSA stands out.
Right. So basically, it leans on knowledge sharing and institutions depending on each other to solve things
Yeah,
instead of operating separately. Fair enough. Well, thank you so much for that, Pranay. That was a really interesting presentation. If you'd like to learn more about what Pranay has been doing over the past few months or any of the other scholars participating in this year's cohort, please feel free to reach out to MediaNama's website or our YouTube channel, where we have much more information on all the other presentations as well. Thanks a lot again, Pranay.
thank you, Ati.